So in Companies Act, there are about 11 questions. First is the meaning of company and features of company. There are 5 features given. What are they? Separate legal entity, perpetual succession. In separate legal entity, there is a case law also. Makaura versus North Insurance Company Limited. So in this, there was one insurance in the name of the company. But this Makaura was only a shareholder. She cannot ask the insurance company for the claim. It can go through only in the name of the company. So company as such is a different than the shareholders or the owners. Second was perpetual succession. Third is limited liability. So shareholders limited liability only to the extent of the face value of the shares held by them. Fourth one, artificial legal person. So as such, company has its own existence. It can purchase property in its own name, sell property in its own name. And fifth one is common seal. Common seal is not mandatory. It is sufficient if any of the 2 directors sign, or 1 director and a company secretary if they have a company secretary. So 5 features. This is the first question. Second is corporate veil theory. In this, there is one famous case, Salomon versus Salomon. Now, what this person did, you remember the case? This person formed a company with himself, his wife, and children. What they did, all of them, the shares of the company, they took it. Plus, what happened? This person, this Salomon, took debentures of the company also. Clear? Now, debentures are having a higher priority than the unsecured creditors. Debentures, when they are issued by the company, it has to be secured. There are 2 types of debentures, secured and unsecured debentures, but most likely it is secured debentures. So this person, Salomon, had taken secured debentures. It had the right over the assets of the company. So now when the company was not running well, what happened? In the order of payment. So what happens when the company is likely to close down? Whatever assets it has, it will have to pay it outside liabilities and then only to the other inside shareholders. So there was one unsecured creditor. This unsecured creditor came and told that the Salomon and this company are one and the same. He only formed the company. He has taken over the shares of the company. He took debentures also of the company. So both are one and the same. But the court told that the Salomon and Salomon Company Limited are 2 different persons. When you are trading with a particular company, you should be aware of what and all liabilities the company has, what and all assets the company has. So unsecured creditor will be paid later. First, secured debentures will be paid. Thereafter, only unsecured creditors will be paid. Clear? Next question is lifting of corporate veil. Now, as we learn corporate veil theory, both company and the people who form the company are different. In certain cases, both will be treated as one and the same. There are some 3 circumstances given. So when you write, if they ask a question on lifting of corporate veil, when you write the point, you're supposed to quote the case law also. Clear? First one is determining the character of the company. So whether it is an enemy company or a friend company. So whom we are dealing with. Here the case law is Daimler Company Limited versus Continental Tire and Rubber Company. Second one, to protect revenue or tax. Just not to pay tax, you cannot form company. In this Dinshaw Manekji Patel, what he did was, he was having huge investments in shares. So because he was having huge investments, he used to receive a higher amount of dividend income. So he was thinking that only in name of one person, if all the shares are there, all the dividend will be taxable at higher rate. I will have to pay higher tax. In India, we have like up to 2,50,000, there is no tax rate. Beyond 2 lakh, the slab rates are there. So what I will do, this dividend and this shares, I will create different companies and transfer the shares to, supposing he's created 5 different companies. So he has transferred the shares to the 5 different companies. Now the dividend income is also split. So as we know that up to 2,50,000, there is no need to pay tax. So as per his planning, to protect or not to pay tax, he did this. But this is not allowed. Just because not to pay taxes, you cannot create companies. If there is any business purpose, you can create companies. Third one, to avoid legal obligation. Here also there is one case, Workmen of Associated Rubber Industry Limited versus Associated Rubber Industry Limited. Now what this fellow did was, now as per there is one act, Payment of Bonus Act. As per that act, it is mandatory that if you are running a factory, you will have to pay bonus to the employees. That bonus is payable only if there is profit. Only if net profit is there, out of that only you should pay bonus to the employees, apart from the fixed wages. Now this person, what he did, he declared the dividend. The profits of the company, he distributed to the shareholders and telling that I don't have sufficient profits to pay bonus. This is not allowed. Who is a shareholder? You yourself are the shareholder. You are taking the entire profits of the company and not paying bonus to the employees. So the employees or the workers of the company file the case against the company. Fourth one, formation of subsidiaries to act as agents. Now here also there is one case, Merchandise Transport Limited versus British Transport Commission. Now this company tried to get a license for vehicles. One company is there, it tried to get a license, but the company was denied the license. What this company did, it formed a subsidiary. Who is a subsidiary company? In which more than 51, supposing X Limited is there, it formed Y Limited. X Limited is having more than 51% shares of Y Limited. Now Y Limited is complying with the conditions and Y Limited got the license. But later on only we came to know that both X and Y, the owners are same. Clear? Formation of subsidiaries to act as agents. So when such subsidiary is formed, the corporate veil can be lifted. Fifth one, company formed for fraud or improper conduct or to defeat law. So if the company is formed for some illegal purpose, then people behind the company, we can question them also. So there are 5 cases where corporate veil can be lifted: trading with enemy, evade taxes, avoid legal obligation, formation of subsidiaries to act as agents, and for illegal or improper purpose. Next is classes of companies. First is on the basis of liability. There are 3 companies on the basis of liability: limited by shares, limited by guarantee, unlimited company. So limited by shares only to the extent of face value. Guarantee company, initially itself when they are becoming members, they will guarantee that at the time of winding up, I am ready to pay so much amount to the company. So in writing they will agree. That is known as guarantee company. Unlimited company, there is no limit on to the extent of liability of the members of the company. How much ever liability is there towards the outside creditors, all the shareholders together will have to settle them. Next, on the basis of members. One person company, a very important topic. It is a private limited company with minimum 1 member. Now in this case, who will be the member of the 1 person company? Only an Indian resident, a citizen of India, who has stayed in India for not less than 120 days. He can become the member of the company. Then he will appoint a nominee also. Who can become the nominee? Minor cannot become the nominee of the OPC. If you have 1 person company, if you incorporate one person company, can you incorporate another 1 person company? No. 1 person, only 1 person company. Clear? Can this 1 person company be converted into another? Now this 1 person company has a nature of private company. Can it be converted into public companies? May be converted into public companies. But it cannot be converted into Section 8 company, where Section 8 is formed for charity. non-profit organizations. But this one-person company cannot be converted into Section 8 companies. Second is private company. Now, how it is decided whether it is a private company or public company? Based on number of members. Now, minimum number of members is 2. Maximum is 200. It has increased the limit to 200. Any restriction on the amount of capital? There is no restriction on the amount of capital. Now underline this line. Maximum number of members 200, excluding present employee cum members and erstwhile employee cum members. So if you're an employee and holding shares of the company, you are not included in that 200 list. If you were already an employee, you left the company, you were employee and are holding shares of the company, such people will not be included in the count of 200. There can be a question on this also. Next is small company. Small company, how is it decided? Based on the amount of paid up share capital and turnover. How much is the amount of paid up share capital? Not exceeding 50 lakhs and which will not be more than 10 crores. Maximum limit 10 crores. Turnover not exceeding 2 crores. What happened? 2 crores and maximum limit is 100 crores. So 50, 10, 200. The updated limits are 4 crores and 40 crores. So when you write your answer, you are supposed to write paid up share capital 4 crores, not exceeding 10 crores. Paid up share capital. Today's limit is from 50 lakhs to... No, you will write paid up capital which does not exceed 4 crores. The maximum prescribed limit is 10 crores. Today's current limit is 4 crores. Turnover, instead of 50 lakhs, instead of 2 crores, it will be 40 crores. Share capital 4 crores. Turnover 40 crores. The maximum limit does not change. Now these amounts can also be changed in the future. Some from 4 and 40 it can be increased, but that 4 can increase maximum up to only to 10 crores. This 40 can increase only maximum up to 100 crores. Clear? Don't write these numbers 50 lakhs and 2 crores. Cut that, and above that itself you write down 4 crores, 40 crores. Nature of small company is also a private company. Next, public company. Minimum number of members 7, maximum there is no limit. Third one, on the basis of control. Holding and subsidiary companies. So a company is said to be a holding company if it is having more than 50% of the paid up share capital of another company. Second possibility is it can control or direct who can become the board of directors of the company. So composition of board of directors of the company. Clear? Third is directly it is holding shares, or it is possible that there are 3 companies X, Y, Z. Y is a subsidiary of X. Z is a subsidiary of Y. Supposing X is having 70% of share capital of Y. Y is having 60% of share capital of Z. Now what happens is indirectly X is having control of Z also. So Z is also a subsidiary of X. So 3 ways in which there can be a holding subsidiary relationship. First is direct investment, more than 51% paid up share capital. Second is controlling who can become the directors of the company, composition of directors. Third is indirect investment through another subsidiary. Clear? See, in the second point, if you see, either at its own or together with one or more of its subsidiary companies. Next, associate company. Associate company, always remember, like holding company, it is more than 50%. Here, associate company means more than 20%. At least 20% ownership has to be there. Then it is termed as associate. So anywhere between 20 and 50, it will be termed as associate. Next, on the basis of access to capital. Access to capital means how the company can raise funds. It can either be a listed company or an unlisted company. Listed company can issue shares to the public and get money, but unlisted company cannot go to the public for issue of shares. Last one, other companies. Government company. So either central government or state government or both central and state government together own more than 51% of share capital of a particular company. Foreign company. It is incorporated outside India but has a place of business in India. It is foreign company. Next, Section 8 company. Again, the Section 8 company is again an important section. Now, Section 8 company is why this company is formed to promote sports activities, charitable objects, art, science, culture. That is only known as Section 8 company. Now, there are some restrictions for this company. To run this company, now what is the benefit of having this company is you need not attach the words limited and private limited. Whenever the words limited, private limited is there, always it is a conscious says that this is business oriented company. So they are allowed not to use those words. So first, this company has to get a license from the government that we are going to form a Section 8 company. If at all the government finds that the purpose of the company is not charitable objects, then they can at any point of time revoke the license. Clear? Next is dormant company. Dormant company means just like that you form a company. Formation of a company is done, but there is no business transaction in it. There is no significant accounting transaction. It is termed as dormant company. Not very active. It is also known as inactive company. Next one, Nidhi company. Nidhi company and all they won't ask. Public financial institution can be a question. Now they have specified a list that these are public financial institutions. What and all are included is LIC, IDFC, Infrastructure Development Finance Company Limited, any specified company referred to in Unit Trust of India Act, institutions referred to by central government, any other institution notified by central government in consultation with RBI. So these 5 specific institutions notified only are public financial institution. Just because it is a finance company giving funds, taking funds, it does not mean it is a public financial institution. Okay? Now, in these public financial institutions also there is a government stake. 51% is held by central government or state government. How many questions we finished? Company features of company, corporate veil theory, lifting of corporate veil. There are 5 things. Then different types of companies. Next is incorporation of a company. Now, in incorporation of company, these documents, whenever a company is incorporated, these documents are required to be submitted. What type of documents? One is memorandum and articles signed by all the subscribers. Second is a declaration given by the person who is involved in the formation of the company. Who and all can be involved in the formation of company? As such, a normal man will think that a company is an organization to be formed, but there are many formalities to be complied with. So a professional will be involved in the formation of the company, either a CA, company secretary, CMA, or an advocate. So these people who are involved, they also have to give a declaration that all the information, whatever is given, is true. Third one, a declaration from each of the subscribers that they are not convict, they are not guilty of any of the frauds. Next, details of the directors of the company, the name, address, and all that. Then details of the members, like subscribers and directors. So there are two kinds of people, subscribers and directors. One is subscriber is, okay, I'm ready to sign the memorandum. Director is, I'm ready to become the director of the company. So when all the documents are submitted, the registrar is satisfied with whatever information they have got is true and correct, he will issue a certificate of registration. Once the certificate of registration is issued, from that date onwards, the company is said to be formed. Supposing the companies, after it is getting formed, the details, whatever they have furnished, is not found to be true and correct, then they levy a penalty. Next question is classification of capital, different types of capital. One of the easiest question. They don't usually ask such question. Nominal authorized registered capital is the maximum capital. Issued, a part of that is issued capital. Subscribed, out of issued capital, how much is subscribed by the public? Called up, paid up, and reserve capital is not. Okay. Next is different types of shares. Equity shares with uniform voting rights, with differential voting rights, and preference shares. Usually one share will have one vote. That is uniform voting rights. Differential voting rights is I can give one share, two votes. That is differential voting rights. But not all companies are allowed to, they have to comply with certain conditions. Today, Tata Motors is having DVRs, differential voting rights. What is the difference between preferential capital and equity share capital? Why it is termed as preferential capital? There are two preferences they hold. What are they? Preference as to the payment of dividends. So before any equity dividend is declared, they will have to be paid off. Then, in the event of winding up, repayment of capital. Before anything is repaid to equity share capital, preferential capital has to be repaid. Next is memorandum of association. Under this, there is one important. Okay, under this, there are different clauses. First one, name clause, registered office clause, object clause, liability clause, capital clause, association clause. You're seeing and telling. Wait. Tell all the 6 clauses again. Why are you seeing? Name clause, object clause, name clause, registered office clause, object clause, liability clause, capital clause, association clause. Now in this there is one doctrine. Yes, doctrine of ultravirus. Can a minor be a signatory to the memorandum? Can a minor hold shares of the company? No. Can a minor be admitted to the benefits of partnership? Partnership, yes. Company, no. Now, what is this doctrine of ultravirus? Ultravirus means beyond powers. Clear? So, directors of the company can act on behalf of the company, but within the powers of the company, within the object clause. Whatever objects they have stated, whatever business transactions they have stated, they have to do it within that object only. Now, here there is a case law. Ashbury Railway Carriage and Iron Company Limited. So in this, what happens? They have stated the object clause, but in that B point, they have written general contractors. So the directors of the company entered into a contract which was not in the objects, stating that this general contractors include that contract. But the court held that the general contractors is related to the previous words attached, business of mechanical engineers. Anything relating to that only, this general contract is there. General contract does not include everything. Clear? Everything relating to railways you cannot do. So whatever the contract they entered into was null and void. Once you enter into an ultra-virus contract, after entering into it, you cannot make changes in the object clause and make the contract as valid. No. The contract as such is invalid and void only. Articles of association is not that important. Doctrine of constructive notice. Constructive notice means any person entering into a contract with the company has read the terms and conditions of both the memorandum and articles. Both memorandum and articles are open documents. That means it is available to the public for inspection and going through. So a person who is entering into a contract with the company is assumed to have read the terms and conditions. Clear? This is known as doctrine of constructive notice. So what will happen if a person enters into a contract which is not there in the object clause itself, and he has entered into contract, and the directors of the company also accepted, and then during this process he has given money. He has given money to the directors of the company. Can he recover them back? Can he recover it back? No, unless otherwise they are friends and all that. Now, no 1 rupee also will be given back to the contractor or the outsider. But there is another doctrine introduced to protect the outsider's interest, which is known as doctrine of indoor management. Doctrine of indoor management, or another name is Turkan rule. According to this doctrine, they state that whenever a contract is entered into an outsider, if there are some internal regulations or internal formalities to be complied with, an outsider need not know whether that has been fulfilled or not. Clear? An outsider need not know. It is sufficient if he has a proof by whom it has been signed, or if the signature is forged or anything. If something wrong has happened in the document, the outsider is not responsible. Clear? But here also there are few exceptions. Here also there are few exceptions. First one, actual or constructive knowledge of irregularity. So if the outsider knows that this is not the signature of Mr. X being his friend, then he cannot escape with doctrine of indoor management. Suspicion of irregularity. If the outsider thinks that there is some type of fraudulent activity going on, there's all the internal regulations have not been followed, there is no time in between, in one day itself, how can they pass a resolution? If there is some kind of doubt coming, then he cannot escape using doctrine of indoor management. He has to personally go and check, verify. Forgery. Forgery is signing on behalf of another person. That's all. So there are around 10 questions in this. First one, company and features of company. Second one, corporate veil theory. Third one, in what circumstances corporate veil is lifted. Fourth one, different types of companies. Incorporation of company. What capital? Different types of capital. Then memorandum of association, the clauses of memorandum. Doctrine of ultra-virus. Okay. Then articles of association, not very important. Doctrine of constructive notice, and then doctrine of indoor management. in this Companies Act, section numbers don't study also okay, but case laws are there. So lifting of corporate wealth theory, all the five points, all the 5 points has case laws. You'll have to study that. Exceptions to the doctrine of indoor management, 3 points with case law. You'll have to study that. You'll have to study Turkan rule case law. You have to study Salmon versus Salmon case law. So Companies Act case law you have to study. Clear? Partnership Act. Now, in this, all sorts of differences are there. Different types of partnership, different types of partners. Correct? The first unit, general nature of partnership. First question is elements of partnership. In that, the last point, business carried on by all or any one of them acting for all. Okay, 5 elements are what? There has to be 2 or more people. There has to be an agreement. There has to be a business agreement to share profits. Business carried on by all or any one of them acting for all. This is also known as principle of agency. Mutual agency principle. So if they ask you how to determine if there is partnership or not, you're supposed to write all the 5 elements. Next, differences. Partnership and company. How many points you will learn? Maximum there is one question for 7 marks, and that is most likely a direct question only. So minimum you have to learn 7 points. Okay, only one question on the question paper is for 7 marks. Others all question for 4, 5, 6. You don't have MCQs, no? Only for MCQs. You don't have MCQs. Next, partnership versus HUF. Anybody who doesn't understand HUF? Is Minor a member of HUF? Shastri? Minor. Is he a member of HUF? No. Minor is not a member of HUF. Minor is a member, but he can't do the business. Minor becomes a member on the day he is born. In the only business which he can become a member is HUF. In case of partnership, only for the benefits of partnership he can come. Clear? Even if you are only 14 years old, you can do the business in HUF. Okay. Next, partnership and co-ownership. What is co-ownership is, they jointly purchase a particular asset, earn income from that asset. There is no business going on. In case of partnership, there is business going on, and that business is to share profits. The purpose is to share profits. But here, co-ownership, there is no business. It is only the asset, and they are agreeing to share the income of that particular asset. Next, partnership and association. Now, association is a group of like-minded people or like-minded professionals joining together and serving each other, providing services to each other. That is known as association. For example, any sort of clubs. But in case of partnership, there is a business going on. Association need not be for profit motive. It can be for a social cause also. There were 3 differences, right? 4. Partnership company, partnership HUF, partnership co-ownership, partnership association. Next, different types of partnership. There are 4 types. First one, partnership at will. So whenever they want, they can close down the partnership if all the partners agree. Partnership for a fixed period. If the partnership was agreed or decided for 5 years, it will automatically close down after 5 years. Next, particular partnership. For a particular business purpose, the partnership is formed. After the purpose is over, the partnership is closed down. General partnership, depending upon the agreement between the partners. Types of partners. Active or ostensible partner, who is actively involved in the working of the partnership. Nominal partner, only the name is lended. Only the name is given. Sub partner, the sub partner is given. There is no person in sub partner. Why are they giving this sub partner? The sub partner, outgoing partner, and all is not required. Next, sleeping or dormant partner who is not actively involved in the business. Partner in profits only. So sometimes the person may tell that I've invested so much, only if whatever profits come, it will be my share. Losses I will not bear. Partner by holding out. Outsiders assume that he's a partner. Partner by estoppel, partner by holding out. He doesn't open his mouth that he is a partner. So in this particular unit, the 4 differences are important. Then how to find out whether there is partnership or not. So for that, you will have to write the true test of partnership or the elements of partnership answer. Then different types of partnership and different types of partners. Okay. Next is relation of partners to one another. Now this is a very interesting topic. How many of you finished learning this year? Sanjay finished, no? Kavya, studied this unit? First topic in the sense, relation of partners. You? Vaishri, really? Finished studying partnership? No. Started partnership. How many chapters have you finished? Contract Act?
I
Started. That also started, not finished.
No, last 3 chapters I finished. Last 3 units of the chapter. First one.
First 2 or first 6 are there.
No, it's not that. That only I have to.
First 6 you didn't finish. And Sale of Goods Act?
That I finished.
Fully you finished. Companies Act? No. Okay. Okay, but law you have 3 days. That 3 days also if you start revising. Yes, listen carefully, Sanjay. In that 3 days, you came last class? Getting back to unit 2. Now you only have to tell what is there in this unit. Relation of partners to one another. Now in this first part, there are few rights and duties given of partners. First is general duties. General duties means they will have to conduct the business in such a manner that it is beneficial to the partnership. Duty to indemnify for loss caused by fraud. If at all any particular partner has done a fraudulent activity, not informing other partners, he has privately entered into a contract, earned profits in the name of partnership, he will have to share the profits to others also. If by entering into such a contract there is a loss, he did not inform other partners, he will have to bear the loss. Loss also take out, other partners take out. Determination of rights and duties of partners by contract between partners. The second point, agreement in restraint of trade. You can make a particular partner, once he is retiring, you can tell a particular partner that you are not supposed to enter into this particular line of business. Clear? That is allowed. Next, rights are given. Right to take part in the conduct of business. Now, ma'am, how to study this? If they ask rights and duties of partner, what to write, how much to write. All the headings you cover. Clear? Inside the headings, you write 2 or 3 lines. But you have to cover all the headings. First one is right to take part in the conduct of business. Second, right to be consulted. Third, right of access to books. Fourth, right of legal hires representatives, their duly authorized agents. Mutual rights and liabilities. Right to remuneration. There can be an agreement that the working partner will be provided remuneration. Right to share profits. If there is no agreement, profit sharing will be equal. Interest on capital, interest on advances, unless otherwise mentioned, the rate of interest on advances is 6% per annum. Right to be indemnified. Right to indemnify the firm. Right to be indemnified means, if at all, supposing there are 3 partners, A is there, B and C are not there. They are traveling. Okay. And there is a contract which A has entered into. But unfortunately, in that contract, there is a loss. He can ask B and C to indemnify him if at all he has entered into a contract with the intention of benefits. But it did not, it was not carried out as planned. It not happened as planned. There was a loss, and that loss can be recovered from B and C also. The intention and the purpose was for the benefits of partnership, but unfortunately there is a loss, then it can be recovered from B and C also. Right to be indemnified is that. Otherwise, if A has paid any liability, B and C were not present or were traveling, that liability amount also, B share and C share, can be recovered. Right to indemnify the firm. If by ignorance, if by any neglect, a particular partner has caused a loss, then that particular partner has to repay the loss to the firm. Clear? But the words used are neglect, ignorance. Next is partnership property. What is included in partnership property? Whatever the partners have contributed to the firm, the assets purchased by the partnership firm, and goodwill. Partnership property includes these 3 things. Property of partner. The personal, the private property of partner is the property of partner only. It does not become the partnership property. Now, supposing a particular partner is having a office, and that office is used for the purpose of partnership. He is claiming rent on that. Is it allowed? Right? His own personal asset. He is not giving it as a capital. A apart from capital, he is allowing the office to be used for rental purposes. Can he claim rent on that? Yes, it can be. It is allowed. Just because it is the asset of particular partner does not mean that he is not entitled to rent. Personal profit earned by partners. What is this personal profit earned by partners is? Using the firm's name, a partner has earned the profits. Then this profit will belong to all the partners. He cannot put it in his own pocket. Rights and duties of partners after a change in the firm. Change in the firm can happen by way of new admission, retirement, or death. Then for a particular term, the partnership was formed, it is finished, and then you form, the same people form another partnership. All these involves a change in partnership. Yes, this question. Implied authority of partner as an agent of the firm. Implied authority means in the agreement they have not given some authority to the firm, but to the partner, but it is implied that he can carry out. What and all are the implied? In the absence of usage or custom, the following are the implied authority does not empower him to. So unless otherwise it is stated in the agreement, he cannot do the following acts. What are those specified acts? Submit a dispute relating to business of the firm to arbitration. He cannot file a case unless otherwise you have been authorized. You cannot file a case unless you get the consent of all the partners. All the partners together only can submit a dispute. Open a bank account. Individually, a partner cannot go and open the bank account. All the partners should be involved to open a bank account. Compromise or relinquish any claim or portion of a claim by the firm. Supposing you have to get something from a particular person, a particular partner cannot decide that, okay, waive, cannot waive. All the partners have to together consent. Withdraw a suit. There is already a case filed. A particular partner cannot decide to withdraw it. Admit any liability. So these decisions, these 8 decisions have to be taken with the consent of all the partners. Clear? Mutual agency principle does not apply here. All the partners together only have to decide. But there is an exception as to when a particular partner can act without informing the other partners. If it is only for the benefit of the firm. There will be one word. In situation of emergency. Now we saw that those acts a single partner cannot do. Page number 4.33. They have given some 4 acts. These acts a particular partner can do. He may pledge or sell the partnership property. He may buy goods on account of partnership, borrow money, contract debts, pay debts on account of partnership. So these acts are beyond the implied authority. You have to by heart those 8 and these 4. Next is extension or restriction of partners' implied authority. Those 8 acts which cannot be done by a single partner, but there can be an agreement between them. That okay, all the court related cases, partner A, you decide. All the bank related cases, all the bank related transactions, partner B is authorized. If there is an agreement between them, this is known as extension of implied authority. The partners have been given authority. There's extension and restriction. Restriction means a particular partner cannot be involved in code-related cases. That is restriction. Now, these extension and restriction will be given with the consent of all the partners. Partner's authority in emergency. Supposing a particular partner does not have authority, no implied authority has been handed over to a particular partner, but a reply has to be given. The cutoff date is tomorrow, and only that particular partner is available. Can he give the reply? Yes. Clear? Yes. Effect of notice to acting partner. Acting partner here means working partner. So a notice given to a working partner implies a notice given to the rest of the partners also. Even though the notice is addressed only to that particular partner, it implies that it is given to everybody. Liability to third parties. Liability of a partner for the acts of the firm. For all the activities, express, implied, all the partners will be responsible. Liability of the firm for the wrongful acts of a partner. If a particular partner has caused some loss to a third party, okay, because of the act of a particular partner, there is a loss to a third party, then who will be responsible? Then we will have to check whether he had the authority to do such act or not. If he had the authority and if it was the benefit of the partnership, then the entire firm will be responsible. If some fraudulent act has been done or unauthorized act has been done, then that particular partner will be responsible. Liability of firm for misapplication by partners. Now here there are two points given. Misapplication means wrong usage of funds or wrong usage of property. Read this example 12. A, B, C, owner of parking place. P parked his car. What did A do? Sold the car. Wrongly applied the property or the funds. Is it valid? The firm has to bear the loss. Only A has done, ma'am. Even if only A has done, both B and C will also be involved. Rights of transferee of partner's interest. Now, what is this? Who is this transferee? Is a partner may transfer his share of profit to another person. This person is known as transferee. What he can do? Can he ask for the books of accounts? No, he cannot ask for the. His interest is only limited to the share of profits. How much is there? How they have calculated it? Why so less? Why so more? All this business he is not. He should be least bothered. He's getting money. He should close his mouth and keep. Okay. Section 30, minor admitted to the benefits of partnership. What are the rights? What are the liabilities? Very important question. Sometimes they ask a direct question based on this. A transferee cannot ask for books of accounts, but a minor can. See, they are picking lines from within the text. So you have to read by heart everything you have to do. Clear? A minor can ask and inspect for books of accounts of the company. Once he turns major, within 6 months, he has to decide whether he wants to continue as a partner or not. Supposing he did not give a public notice. After he turns majority, within 6 months, he has to decide and give a public notice to that effect that he wants to continue as a partner or he does not want to. Both the ways, he has to give a public notice. Supposing he does not give public notice, then what will happen? It will be assumed that he is a partner of the. Liabilities before majority, no personal liability, no insolvency, nothing. After attaining majority, from the date the public notice is given or he fails to give a public notice, then after 6 months, from that date onwards, he is admitted to he is a partner of the firm. From that day onwards, he will be personally liable to all the third parties. For what acts? From that day or from the beginning? No. From the beginning. For all acts done even before he was a minor. It is, wait, I'll tell you where it is. Page number 4.38. When he elects to become a partner, first point, he becomes personally liable to the third parties for all the acts of the firm done since he was admitted to the benefits of partnership. Share of profits remains the same. This is there, no? This section 30, you learn it of as such. Like understand it and learn it of as such. Legal consequences of partner coming in and going out. Admission of a partner from the day a new partner joins in, from that day only his liability starts. Retirement. In case of retirement also, he is supposed to give a public notice. Expulsion. When a partner can be expelled, there are 3 conditions given. Mark that. All the 3 conditions have to be present. Only then expulsion is possible. Power of expulsion should be there. The power has been exercised by majority of partners and it has been exercised in good faith. Insolvency. What will be the effect of insolvency? The insolvent partner immediately stops to become a partner. He cannot continue to become the partner. From what date? On the date on which the adjudication order has been passed, that he is an insolvent. Whatever estate is there, estate of that insolvent partner will not be liable for the acts of the firm. The firm is not liable for any of the act of the insolvent partner after that date. Sometimes insolvency of a partner results in dissolution of the Section 36 is also important. Right of outgoing partner to carry on competent business. If he is in the similar line of business, he should not use the existing firm's name. He should not show that I was a partner in this firm. So supposing, usually what happens when you work in Big Four, supposing you worked for 5 years and thereafter you quit and you start your own firm. You try to solicit their clients also. Because you have been working there for 5 years, you know the clients, you try to take away the clients with you. This is only known as you, but you're not supposed to do that. Section 37, it comes in accounts also. You remember? There are two options available to an outgoing partner. One is the outgoing partner keeps the capital in the business itself. He does not take away his capital. So on that capital, he has two options. One is he can get interest at the rate of 6% per annum. Second is he can get the share of profits based on the amount of capital invested, not profit sharing. Okay. Unit 3 is about registration and dissolution. The registration of firms, is it mandatory? It is not mandatory to register partnership firms. But what are the benefits of registration? We can file a suit. Yeah? In the name of the firm, you can file a suit. The partner can file a suit against the firm. Even if it is unregistered, can a third party file the sue against the firm? Sue the firm? Yes. We cannot file a case against third parties, but a third party can file a suit against the firm. Difference between dissolution of firm and dissolution of partnership. Dissolution of partnership is only changes among the partners. Can be an admission or retirement. Dissolution of firm is complete closure. In dissolution of firm, we prepare realization account. In dissolution of partnership, we prepare revaluation account. Dissolution of partnership, does it require court interference? No. But in case of dissolution of firm, court may be involved. There are two types of dissolution. Dissolution with the order of court, without the order of court. Without the order of court is we willingly, okay, this many years we have worked, we will close it and we will take away whatever assets we have. That is without the order of court, by agreement. Compulsory dissolution, when will the firm be compulsorily dissolved? One person or all the partners turn insolvent. Second possibility is some unlawful or illegal business has been carried out. When will the court dissolve a firm? All the partners turn insolvent, unsound mind, or some type of incapacity to continue the partnership. Misconduct. Misconduct is not carrying on business for the benefits of partnership. For their personal profits, they are doing the business and carrying out some fraudulent activities. So that is misconduct. Persistent breach of agreement. What type of breach they are doing? Embezzlement. Embezzlement is nothing but theft of cash. Whatever cash they are earning, one of the partners is taking. Keeping erroneous accounts. Books of accounts are not maintained properly. Holding more cash than allowed. Refusal to show accounts despite repeated requests. So one partner is continuously, who is an active partner, and other two partners are not much active. That active partner is doing all this. Persistent breach of agreement. Transfer of interest. Entire interest is sold to another party. Then this partnership will come to an end. Continuous losses. No use of running the partnership. We are not doing business for making losses. We are doing it only for earning profit. So better will be closed. Just and equitable grounds. Here also headings properly learn, understand the meaning properly in case of dissolution. Consequences of dissolution. What will happen after dissolution? After dissolution, like when they have decided to dissolve, what steps to carry forward? Liabilities to be paid off. So they have all the rights and duties to carry on the business or do all such acts for the purpose of dissolution. First, we have to pay off the outside liabilities, and thereafter partner's loan, and thereafter any capital. If the assets are not sufficient, then the deficiency have to be brought in by the partners. The assets of the firm shall first be utilized to pay what? The liabilities of the firm. If any excess assets are there, then it can be used for the personal debts of the partners. Similarly, opposite. The partner's assets shall first be utilized to pay partner's personal debts. Thereafter, it can be utilized to pay liabilities of the